Alrighty, good morning, everybody. I thought I would come in today and say good morning, talk a little bit about the case, what's going on for the few minutes we have. It looks like until 9:15 when the jury is going to be brought in. Um, so I'm happy to be back in studio. Normally I do this, but it's for numerous reasons. I've been on the road quite a bit and out of studio and doing a lot of remote work, but Adelson case, I figured, is big enough to come back in and talk to you guys and have some conversation. So first off, welcome to all the new mods out there that got their blue jackets. So congratulations to everybody. I count on you guys to keep the community um, keep the community going. Keep your eye on things if I'm not able to. As always, communicate to me. You can email me at justicewatchlive@gmail.com or justiceasaprocess@gmail.com. Either one, if there's ever a concern or question. And anybody, that goes for anybody. So let's talk about what's going on here, guys. This is going to be an interesting case, and I think a lot of people have to understand that this is one of those what I call legal nuance cases, because the defense is going to rely on holding the state to the law. And you see them doing that, just like we just saw with the proffer, and requiring them to lay proper foundation before any emails come in or before any evidence is presented. Um, and that's exactly what they're going to be doing as far as the way they're defending this case, because what they're going to be relying on to defend this case is the idea in Florida law that says that if a case that if the prosecution's case is circumstantial, that you have to eliminate any and all uh, possible explanations of innocence, and that's what they're going to suggest. That's what they're going to be relying on in this case. And it's somewhat difficult for people to understand of when you're looking at a case and you're thinking, okay, there's suspicion and there's this, but you've got to eliminate any and all reasonable explanations of innocence. Now, is that going to be necessarily um, always going to be followed by jurors? No, but this goes back to when I watched, of course, this was right before the channel started, the Charlie Adelson case, and it was a case that a lot of people had uh, when they were looking at the way Rashbaum was defending the case. As Rashbaum said, "Hey, we have a reasonable doubt in the case because we've laid out a reasonable potential way to explain all the evidence." Now, the jury, of course, can the jurors are triers of fact. So, if they decide something is proof beyond a reasonable doubt, or they decide it is, they want to cross a bridge, they can do it. But the idea in that case was, we're going to say that there was this extortion attempt, and we're going to put Charlie Adelson on the stand. He's going to present our evidence for us. He's going to say this is what happened, and we're going to suggest that, can you say it didn't? And that was kind of what they put forward. Of course, that jury said, well, we're going to say you didn't. Now, Donna Adelson's case is a totally different animal, because they're not going with the extortion defense. They're actually going to be going with she didn't know what was going on beyond she was upset about a divorce. And that's why these emails are so important, because they're trying to keep out the stuff that would make her look really, really bad. But they're going to say she's a grandma who's upset and wants her kids here, and prove that she crossed the line. Is there anyone that was in the room that's going to say, hey, um, we heard her, we saw her, we heard her making arrangements? And if she could say, hey, I didn't know this was between Wendy and Charlie, which is where you're going to see a lot of the phone con, which I think where the defense is going to go with this. But they're going to say, okay, they didn't prove beyond a reasonable doubt that she knew. They couldn't prove the conspiracy. And they're going to rely heavily on trying to block the prosecution at every route by holding them to the standard and requiring the judge to hold the state to the standard on the evidence that can come in, and then make a sufficiency of evidence argument at the end of this. So, will it work? Probably not. I think realistically speaking, I think the jury's going to look back here and say, let's look at all the evidence that they have. They've got the bump, they've got the consciousness of guilt after the bump, they've got the phone activity, they've got the fact that they're going to show that she was heavily involved in all decision making with her kids. She was heavily involved with Charlie and at Wendy, and of course, you're going to get down the line to when Charlie gets convicted and she hears she's being arrested. They're going to have the consciousness of guilt evidence that she's trying to flee. And then you're going to have, of course, the jailhouse snitch people that are going to come in and say, wow, look, she was, um, I think if my understanding from the opening argument and looking into or opening statement, looking into what's in the files, they're going to be saying that she was attempting to find people in the jail to say they did time with Catherine McVanowa and that they were saying that her story somehow was different. Um, it's it, it, when you take it in totality, I think they're going to say, okay, this whole thing says she knew about it. I think the jury's going to probably be okay with it, unless you get a juror or two on the jury. And for those of you that think it's not possible, remember the Catherine McVanowa case, which again, Catherine McVanowa was charged with the conspiracy aspect and not actually doing it. McVanowa actually got a hung jury in her first trial. So it's very possible that the first run at this could result in a hung jury. I think that's the potential best outcome for Donna, although you never know. I mean, it's possible that at the end of this case, if the defense puts up enough roadblocks and blocks enough things from coming in, and again, remember on Friday, a lot of people found it controversial when I put the video up of Rivera's testimony, but Rivera did in fact say that she wasn't involved. And the part that I guess has gone past people is the reference to the deposition where it was on defense cross. She says, I asked you to put who you knew was involved. And he put X's on Donna and he put X's on Harvey. And he agreed, yes, I said they weren't involved, to his knowledge. So, that is now, here's the thing. Rivera has never said he had any knowledge of who did what, because Rivera's not the inside guy. We have to watch McVanowa and say, what's McVanowa going to say now? As far as, remember, there's also a piece of key evidence she's going to say. And the question will be whether or not they're going to be able to get a hearsay exception. Although they should be able to get one because Donna Adelson, but this is going to be their argument. There is a hearsay exception that says that that you can get a statement from a co-conspirator is allowed to come in. So, but they've got to prove the conspiracy. This is why you hear the defense arguing and saying, I haven't put up evidence. In order for them to get the statement is going to be the statement in regards to the money being wet that Charlie allegedly made to her, which would absolutely be a hearsay, or would need a hearsay exception for it to come in. And we'll see what comes up with that. Looks like court's coming up. But guys, watch this. This is what, like I said, this is going to be very interesting because the defense is going to be based on a sufficiency of evidence test. And that is exactly, many people say, well, what can a defense be when the evidence is so strong and overwhelming? Well, this is what it is. You're going to ask the state to come in and prove their case. And that's what they're going to do. And we're going to see we're going to test that as we're watching this. And as I put it out and check out the Justice Fusion report or Justice Breakdown reports and the Justice Breakdowns that we're doing, because we're going to be talking about that and we're going to be judging it with a impartial lens on how are they actually doing and what's happening. Anyways, with that said, guys, I'll be in and out today on the breaks. Appreciate everybody watching. Hit the like button. Get subscribed if you're not subscribed. And I'll talk to you guys real soon. Let's jump into the courtroom.